For this video, we are going to talk about search warrants, and we are also going to talk about Article 129 of the Revised Penal Code on search warrants maliciously obtained and abused in the service of those legally obtained. And we are also going to discuss Article 130, searching domicile without witnesses. What is a search warrant? A search warrant is an order in writing issued in the name of the people of the Philippines, signed by a judge, and directed to a peace officer commanding him to search for personal property described therein and bring it before the court. This is found in Rule 126, Section 1 of the Revised Rules on Criminal Procedure. When you say order in writing, it means a written order. A verbal order, therefore, is void. And when you say in the name of the people of the Philippines, it is because it is the state that intrudes into a person's privacy or the privacy of one's abode. And when you say signed by a judge, it is only a judge who can issue a search warrant. And when you say directed to a peace officer, only a public officer vested with authority to effect arrests or implement searches can implement a search warrant. What about personal property? Personal property are those enumerated in Articles 416 to 418 of the Civil Code, but in general they refer to all things which can be transported from place to place, or they may also refer to any property which is not included in the enumeration of real properties in Article 415 of the Civil Code. But in the case of Laod versus People, the Supreme Court said that personal property for purposes of or in reference to the issuance of a search warrant actually refers to the thing's mobility and not to its capacity to be owned or alienated by a particular person. Okay? Articles 416 to 418 refer to its capacity to be owned or alienated by a particular person. In relation to a search warrant, personal property refer to things that bear a direct relation to the offense committed. Like, for example, a search warrant relating to the search or recovery of human remains of people subject of salvagings. Even if human remains are not personal property per se, or they are not personal property in the sense of Articles 416 to 418 of the Civil Code, but for purposes of or in connection with the issuance of a search warrant, they are subsumed under the phrase personal property because human remains bear a direct relation to the offense committed. In that case, the offense committed was murder, and the police officers applied for a search warrant to recover human remains of people that were allegedly salvaged. What is the purpose for issuing a search warrant? It is for the purpose of searching and seizing personal property, either personal property subject of the offense, or personal property stolen or embezzled and other proceeds or fruits of the offense, or it could be personal property used or intended to be used as the means of committing an offense. This is found in Rule 126, Section 3 of the Revised Rules on Criminal Procedure. When you say personal property subject of the offense, an example of this can be illegal drugs in the possession of a drug pusher, stolen or embezzled and other proceeds or fruits of the offense. An example of this can be the car stolen by a car napper. And when you say personal property used or intended to be used as the means of committing an offense, An example of this can be the firearms and explosives in the possession of a suspected terrorist. Now, why would a judge issue a search warrant? The judge does not motu proprio or on his own issue a search warrant. It must be applied for by the public officer who has knowledge of facts personally known to him that the things to be seized are in the place sought to be searched. In the case of Pilipinas Shell Petroleum Corporation versus Romars International Gases Corporation, the Supreme Court clarified that a search warrant merely constitutes a process. It is not a criminal action in itself. At the time a search warrant is applied for, or at the time a search warrant is issued, there is yet no criminal case or criminal action pending in court in connection with that search warrant. It is only after the search warrant turns out successful because, like for example, the police officers were able to recover personal properties subject of the offense, that they will be filing a criminal action against the person in possession of the said personal properties. Because a search warrant is akin to a writ of discovery. It is a special and peculiar remedy, drastic in nature, and made necessary because of public necessity. Now, against whom should the application for a search warrant be filed? It should be filed against the person in actual possession or against the person who has constructive possession of the place where the things to be seized are located or stored. Possession under the law includes not only actual possession but also constructive possession. Actual possession exists when the drug is in the immediate possession or control of the accused. For example, X placed the sachets of shabu inside the small bag he was carrying. On the other hand, constructive possession exists when he has the right to exercise dominion and control over the place, room, house, or building where the illegal drug is found. Example, the shabu found inside the room where X is staying. Exclusive possession or control is not necessary. Take note of this. The accused cannot avoid conviction if his right to exercise control and dominion over the place where the contraband is located is shared with another. So for example, the accused is sharing a room with another person, and the application for a search warrant states that the contraband is located in the room where the accused is staying, although in that room it is being shared with another person. By itself will not invalidate the search warrant because, to repeat, as ruled in the case of People versus Trinidad, exclusive possession or control is not necessary. If the implementation of the search warrant turns out successful, what happens next? If the person subject of the search warrant was present during the implementation, then he will be arrested, this even without a warrant of arrest, because this is an example of a valid warrantless arrest. And he will then be subjected to an inquest proceeding. You already know what an inquest proceeding is, as I have already discussed in my previous video. For example, the 2 kilos of shabu was found in X's house. X was present during the implementation of the search warrant. Here, X will be arrested and a criminal complaint will be filed against X before the fiscal, who will then conduct an inquest proceeding. If X in the example was not around during the said implementation, a criminal complaint will still be filed against X, but this time under the regular preliminary investigation procedure as found in Rule 112, Section 3 of the Revised Rules on Criminal Procedure. Here, the police officers who implemented the warrant will file a complaint against X before the fiscal. The fiscal will then issue a subpoena requiring X to submit his counter affidavit within 10 days from service. Within 2 months from the filing of the complaint, the fiscal will then have to issue a resolution whether or not to file an information or a criminal case against X. So I'm just giving you a synopsis of what happens in a preliminary investigation procedure. What shall the police officers do with the property seized? The officer seizing property under the warrant must give a detailed receipt for the same to the lawful occupant of the premises in whose presence the search and seizure were made, or in the absence of such occupant, must, in the presence of at least 2 witnesses of sufficient age and discretion residing in the same locality, leave a receipt in the place in which he found the seized property. This is so provided in Rule 126, Section 11 of the Revised Rules on Criminal Procedure. So here, after the seizing officer is able to seize the personal property described in the warrant, he is mandated by the rule to issue and give a detailed receipt to the lawful occupant. A receipt is basically a listing down of the personal property or properties recovered or seized from the house of the lawful occupant. Or if the lawful occupant is not around at the time of the search, then the police officer will still be obliged to issue a receipt, but this time he may leave such receipt in the place in which he found the seized property, provided that it must be made in the presence of at least 2 witnesses of sufficient age and discretion residing in that area or locality. What I mean by this is that the 2-witness rule or the requirement of 2 witnesses will only be had if the lawful occupant is not present at the time of the search. Because if the lawful occupant was present at the time of the search, then the 2 witnesses will no longer be necessary. Moreover, the police officers who implemented the search warrant must forthwith make a return on the search warrant and deliver the property seized to the judge who issued the same, together with a true inventory thereof duly verified under oath. So aside from issuing and giving a receipt, the police officer also must forthwith, meaning immediately or right away, make a return on the search warrant and deliver the property to the judge who issued the search warrant. A return is basically report in writing to be made by the police officer for the purpose of informing the judge on the outcome or result of the implementation. So, as I said, aside from issuing and giving or leaving a receipt, the police officer who implemented the search warrant must also make a report to the court, and at the same time, forthwith or immediately deliver the property seized to the judge who issued the said warrant, and attached therewith or together with the personal property seized, submit a true inventory of the personal property seized. Now, oftentimes, the receipt and the inventory are embodied in one document. So, the police officer may only need to furnish the same copy of the receipt to the issuing court, because as I said, The receipt and the inventory are usually embodied in the same or contained in one or the same document. And when you say true inventory, it is also the listing down of all the properties seized in connection with the enforcement of the search warrant. If the implementation of the search warrant is not successful, meaning there was no, or the police officer implementing the search warrant was not able to recover or seize the personal property described in the search warrant, what happens next? The person subject of the search warrant cannot be arrested and no criminal charge can be filed against him because why? Why? The police officer was not able to recover property subject of the offense, for example. So how can there be a case filed against the person subject of the warrant when no personal property described in the said warrant was recovered or seized at the time of the implementation? But just the same, the police officer who implemented the search warrant must still forthwith make a return thereof. So yung isasubmit ng police officer, return na lang. Wala na siyang maisasubmit na personal property or inventory because there was no property that was seized or recovered in the first place. What are the duties of the judge who issued the search warrant? 10 days after the issuance of the search warrant, the issuing judge shall ascertain if the return has been made, and if none, shall summon the person to whom the warrant was issued and shall require him to explain why no return was made. If the return has been made, the judge shall ascertain whether or not Section 11 of Rule 126 has been complied with and shall require that the property seized be delivered to him. The judge shall see to it that Section 12A of the same rule has been complied with. Now, if the police officers fail to, number one, give a detailed receipt or leave a receipt, or if the police officer or officers fail to deliver forthwith the property seized together with the inventory thereof, or if the police officer or officers fail to explain why no return has been made, or if the police officer or officers fail to make a return on the search warrant, the same shall constitute contempt of court under Rule 126, Section 12. How many days is a search warrant valid? A search warrant shall be valid for 10 days from its date, meaning the date stated in the search warrant. Take note, 10 days from its date, not 10 days from receipt by the officer to whom the warrant is issued. And after 10 days, it shall be void. It is non-extendable. If the search warrant is implemented, let's say 11 days after its issuance, any personal property seized in connection therewith becomes inadmissible for any purpose in any proceeding. Reason? The search warrant at the time of the seizure has already become void, such that even if, let's say, contraband was searched or the prohibited articles described in the warrant was discovered by the police officer concerned and seized thereafter, that will not be used against the person subject of the search warrant. No criminal case will be filed against that person. And on the contrary, it will be the officer who implemented a void search warrant will be subjected to criminal liability. And what is that criminal liability? that officer will be held criminally liable for violation of domicile under Article 128. Now, at what time must the search be made? The warrant must direct that it be served in the daytime. So the general rule here is a search warrant must be served in the daytime unless the affidavit referring to the affidavit of the applicant or the affidavit of the witnesses of the applicant assert that the property is on the person himself or in the place ordered to be searched, in which case a direction may be inserted that it be served at any time of the day or night. What does this mean? The warrant must state that the same may be served at any time of the day or at any time of the night because of the circumstance mentioned in Rule 126, Section 9. Can the police officer break open any door or window or any part of a house to effect the search? The answer is yes. The officer, if refused admittance to the place of directed search after giving notice of his purpose and authority, may break open any outer or inner door or window of a house or any part of a house or anything therein to execute the warrant or liberate himself or any person lawfully aiding him when unlawfully detained therein. Should there be witnesses other than the police officers during the search? The answer is yes. Under Rule 126, Section 8, no search of a house, room, or any other premise shall be made except in the presence of the lawful occupant thereof or any member of his family or in the absence of the latter, two witnesses of sufficient age and discretion residing in the same locality. A violation of this rule will make the officers liable under Article 130, searching domicile without witnesses. When you say lawful occupant, it refers to the person whose domicile, papers, or effects are subject of the search. What about the phrase two witnesses of sufficient age and discretion? Since the rule mentions two witnesses, it must be two, not one. And a person of sufficient age and discretion is one who has attained the age of 18 and is considered to have enough discernment. Discretion is defined as the ability to make decisions which represent a responsible choice and for which an understanding of what is lawful, right, or wise may be presupposed. So, the definition or description rather of the phrase two witnesses of sufficient age and discretion was given in the case of Prudential Bank versus McDermott Jr. Where shall an application for search warrant be filed and in what court? Rule 126 Section 2 provides that an application for search warrant shall be filed in number 1, any court within whose territorial jurisdiction a crime was committed, or number 2, for compelling reasons stated in the application, any court within the judicial region where the crime was committed if the place of the commission of the crime is known, or any court within the judicial region where the warrant shall be enforced. However, if the criminal action has already been filed, the application can only be made in number 3, the court where the criminal action is pending. The phrase any court within whose territorial jurisdiction the crime was committed refers to either the regional trial court or the next lower courts like the MTC, MTCC, MCTC, and Metropolitan Court, or any court for that matter that has jurisdiction over the place where the alleged crime was committed. For example, if the crime happened in Ormoc City, it will be the RTC or the MTCC of Ormoc City that may or that can act on the application. It must be noted that nothing in the above quoted rule does it say that the court issuing a search warrant must also have jurisdiction over the offense. A search warrant may be issued by any court pursuant to Rule 126, Section 2 of the Revised Rules on Criminal Procedure, and the resultant case may be filed in another court that this time has jurisdiction over the offense committed. Why? Because what controls is that a search warrant is merely a process. I already emphasized this in the previous slide. It is merely a process generally issued by a court in the exercise of its ancillary jurisdiction and not a criminal action to be entertained by a court pursuant to its original jurisdiction. Hence, in certain cases when no criminal action has yet been filed, any court for that matter may issue a search warrant even though it has no jurisdiction over the offense allegedly committed, provided that all the requirements for the issuance of such warrant are present. This is the case of People versus Honorable Castillo Sr. For example, the MTC has the authority to issue a search warrant involving an offense in which it has no jurisdiction, like a search warrant for illegal drugs. Note number 1. The concept of venue of actions in criminal cases, unlike in civil cases, is jurisdictional. The place where the crime was committed determines not only the venue of the action, but is an essential element of jurisdiction also. It is a fundamental rule that for jurisdiction to be acquired by courts in criminal cases, the offense should have been committed or any one of its essential ingredients should have taken place within the territorial jurisdiction of the court. Territorial jurisdiction in criminal cases is the territory where the court has jurisdiction to take cognizance or to try the offense allegedly committed therein by the accused. Thus, it cannot take jurisdiction over a person charged with an offense allegedly committed outside of that limited territory. Just to emphasize again, an application for a search warrant is a special criminal process rather than a criminal action. We should not equate the application for and the obtention of a search warrant with the institution and prosecution of a criminal action in a trial court. The requisites, procedure, and purpose for the issuance of a search warrant are completely different from those for the institution of a criminal action. Applications for search warrants are not criminal actions themselves. A search warrant merely constitutes a process, generally issued by a court in the exercise of its ancillary jurisdiction and not a criminal action to be entertained by a court pursuant to its original jurisdiction. Proceedings for said applications are not criminal in nature and thus the rule that venue is jurisdictional does not apply thereto. Now, the phrase compelling reasons. In the case of Pilipinas Shell Petroleum Corporation versus Romars International Gases Corporation, the Supreme Court stated that the wordings of this provision, itong phrase na compelling reasons, is of a mandatory nature, requiring a statement of compelling reasons if the application is filed in a court which does not have territorial jurisdiction over the place of commission of the crime. Example of a compelling reason. Based on verified intelligence reports, one of the court employees in the court where the police officers were supposed to apply for a search warrant was found to be an accomplice of drug lord X, the person subject of the application for a search warrant. Here, the police officers may apply in any court within the judicial region where the crime was committed if the place of the commission of the crime is known, or any court within the judicial region where the warrant shall be enforced. Let us say the place where the dangerous drugs are stored was or is in a house in Ormoc City. The court that has territorial jurisdiction over Ormoc City is the Regional Trial Court of Ormoc City or the Municipal Trial Court in cities of Ormoc City. But if it is found out that a court employee or any person working in the Hall of Justice is found to be connected with the person subject of the search warrant, and in order that the application for a search warrant or the search warrant itself will not be leaked to the person connected with the person subject of the warrant, the police officers in that situation may apply for a search warrant in another court that has no jurisdiction over the place where the offense was committed. So, the police officers may file an application for a search warrant in Tacloban City. And that is what? A compelling reason which is allowed under the rules. What are the requisites for the issuance of a valid search warrant? Rule 126 Section 4 states, a search warrant shall not issue except upon probable cause in connection with one specific offense, to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce, and particularly describing the place to be searched and the things to be seized, which may be anywhere in the Philippines. Requisites. Based on the statement in Rule 126 Section 4. Number 1, probable cause is present. Number 2, such probable cause must be determined personally by the judge. Number 3, it must be in connection with one specific offense. Number 4, the judge must examine in writing and under oath or affirmation the complainant and the witnesses he or she may produce. Number 5, the applicant and the witnesses testify on the facts personally known to them. And number 6, the warrant specifically describes the place to be searched and the things to be seized. So those are the requisites based on the rule found in Section 4, Rule 126. Let's talk about probable cause in connection with the issuance of a search warrant. Probable cause are or is such facts and circumstances which would lead a reasonably discreet and prudent man to believe that an offense has been committed and that the objects sought in connection with the offense are in the place sought to be searched. Probable cause exists if a practical, common sense evaluation of the facts and circumstances show a fair possibility that dangerous drugs will be found in the asserted location. Sufficient information must be present to allow a judge to determine probable cause, and his action cannot be a mere or should not be a mere ratification of the bare or unsubstantiated contention of others. This was decided in the case, or this was the pronouncement of the Supreme Court in the case of Abuan versus People. The phrase, such probable cause must be determined personally by the judge. What does it mean? In People versus Choi, the Supreme Court said that the searching questions propounded to the applicant and the witnesses depend largely on the discretion of the judge. Although there is no hard and fast rule governing how a judge should conduct his examination, it is axiomatic that the examination must be probing and exhaustive. Kasi judge nga eh. Okay? Not merely routinary, general, peripheral, perfunctory, or pro forma. The judge must not simply rehash the contents of the affidavit but must make his own inquiry on the intent and justification of the application. The questions should not merely be repetitious of the averments stated in the affidavits or depositions of the applicant and the witnesses. If the judge fails to determine probable cause by personally examining the applicant and his witnesses in the form of searching questions before issuing a search warrant, grave abuse of discretion is committed. The phrase, it must be in connection with one specific offense. What does that mean? In Philippine Long Distance Telephone Company versus Alvarez, the Supreme Court had occasion to rule that if the caption and or body of the search warrant show that it is issued for more than one offense, like for example, the warrant indicates that or shows that it is for violation of RA 9165, but in that same warrant, it was also issued for violation of RA 10591 on illegal possession of firearms, then the same becomes a scattershot warrant and therefore void. The one specific offense requirement reinforces the constitutional requirement that a search warrant should issue only on the basis of probable cause. Since the primary objective of applying for a search warrant is to obtain evidence to be used in a subsequent prosecution for an offense for which the search warrant was applied, a judge issuing a particular warrant must satisfy himself that the evidence presented by the applicant establishes the facts and circumstances relating to this specific offense for which the warrant is sought and issued. In the landmark case of Stonehill versus Diokno, the Supreme Court, in declaring as null and void the search warrants which were issued for several laws, violations of laws like violation of central bank laws, violation of the Traffic and Customs Code, violation of the Internal Revenue Code, and violation of the Revised Penal Code. So there was only one search warrant and it contained or it was issued for several violations of law. How did the Supreme Court decide on the validity of the said search warrant? The court said, in other words, no specific offense had been alleged in said applications. The averments thereof with respect to the offense committed were abstract. As a result, it was impossible for the judges who issued the warrants to have found the existence of probable cause, for the same presupposes the introduction of competent proof that the party against whom it is sought has performed particular acts or committed specific omissions violating a given provision of our criminal laws. As a matter of fact, the applications involved in this case do not allege any specific act performed by herein petitioners. It would be the legal heresy of the highest order to convict anybody of a violation of central bank laws, traffic and customs laws, international revenue code, internal revenue code, and revised penal code without reference to any determination or rather without reference to any determinate provision of said laws. So tingnan mo yung search warrant na in-issue in the case of Stonehill versus Diokno. There were many alleged violations committed, and at the same time, there was no specific provision of law described or mentioned in the search warrant itself. Like for example, the search warrant was merely issued to search for personal property in violation of customs laws. What specific provision in the Tariff and Customs Code was being violated by the person subject of the warrant? That was the point, in the case of Stonehill versus Diokno, that it became impossible for the judges, or it will already be impossible for the judges to properly determine probable cause because there was no mention of a specific provision that was violated. This statement, the judge must examine in writing and under oath or affirmation the complainant and the witnesses he or she may produce. What does that mean? The phrase in writing there means that the examination must be recorded, meaning to say there must be a stenographer during the examination of the applicant and the witnesses by the judge that will record the searching and probing questions made by the judge or propounded by the judge to the applicant and the witness or witnesses the applicant may have or may produce during the said examination. And the phrase under oath there means a solemn formal calling upon God to witness to the truth of what one says. What about the phrase the applicant and the witnesses testify on the facts personally known to them? Here, in the case of People versus Gabiosa, the Supreme Court said that there is no need to examine both the applicant and the witness or witnesses if either one of them is sufficient to establish probable cause. When the affidavit of the applicant contains sufficient facts within his personal and direct knowledge, it is sufficient if the judge is satisfied that there exists probable cause. In the case of Laod versus People, the Supreme Court, in describing the phrase, the warrant specifically describes the place to be searched and the things to be seized, the Supreme Court said that a description of a place to be searched is sufficient if the officer can ascertain and identify the place intended and distinguish it from other places in the community. Thus, a search warrant may be said to particularly describe the things to be seized when the description therein is as specific as the circumstances will ordinarily allow, or when the description expresses a conclusion of fact, not of law, by which the officer may be guided in making the search and seizure, or when the things described are limited to those which bear direct relation to the offense for which the warrant is being issued. Article 129. Search warrants maliciously obtained and abuse in the service of those legally obtained. How is this crime committed? Let us read the provision first. In addition to the liability attaching to the offender for the commission of any other offense, The penalty of arresto mayor maximum to prisión correctional minimum and a fine not exceeding 200,000 shall be imposed upon any public officer or employee who shall procure a search warrant without just cause, or having legally procured the same, shall extend his authority or use unnecessary severity in executing the same. There are two punishable acts here. Number one, by procuring a search warrant without just cause, or number two, by exceeding his authority or by using unnecessary severity in executing a search warrant. Let us go over some keywords here. The phrase without just cause. When it appears on the face of the affidavits filed in support of the application or through other evidence that the applicant had every reason to believe that the search warrant sought for was unjustified. For example, the applicant or witness lied under oath and merely planted evidence during the implementation of the search warrant. That is issuing or procuring a search warrant without just cause. And the applicant or witness who lied under oath may even be held criminally liable for perjury. The phrase exceed his authority. Here, if the officer seizes other items not mentioned in the search warrant, however, contraband articles like a hand grenade or a sachet of shabu can be seized even if inadvertently found during the implementation of the search warrant. What about unnecessary severity? An example of this is if during the implementation of the search warrant, the officer recklessly or intentionally destroyed the appliances inside the house of the lawful occupant.